Tonight, we begin with a development that U.S. immigration officials, legal experts, and green card holders across the country had feared, anticipated, and in some cases, quietly prepared for. A law that unfolded not over years of negotiation, but in a matter of days. Days that will change how millions of permanent residents live in this country. Days that will determine who stays, who faces new requirements, and who must act now or risk consequences they may not be able to reverse. Days that have already sent shockwaves through immigrant communities from Los Angeles to New York, from Houston to Chicago. What Congress did today crossed a line that immigration advocates had hoped would hold. And when that line broke, the legal community did not hesitate. They responded with urgency, with clarity, and with a direct message to every green card holder in America. Pay attention because this affects you personally. For months now, there had been signals, not official press releases, not formal legislative announcements, just signals, that the federal government was preparing something significant in the immigration space. Congress has been active, yes, but they have been unusually deliberate in their activity. Their moves have followed a certain rhythm, a pattern, almost a choreography. But what set off alarm bells in Washington legal circles this week was that the usual public debate went silent. Immigration attorneys who monitor congressional movement know the indicators. The committee hearings that suddenly close to the public, the draft language that stops circulating among advocacy groups, the agency briefings that go off the record, the sudden disappearance of lobbyist counterproposals, all of that went quiet. And whenever legislative momentum goes quiet in Washington, it means something is about to get loud. Early this week, legislative trackers and immigration law firms detected what they described as an accelerated procedural push, including language insertions that had not been seen in any public draft in over 2 years. These are the kinds of moves that lawmakers only deploy when they are signaling something very specific: a fast-track passage, a policy reversal, or a sweeping structural change to existing immigration frameworks. Legal observers didn't know which category this fell into, or whether it fell into all three at once, but what they did know was that Congress was changing its posture on permanent residency requirements. And when a legislative body shifts its posture on immigration without extended public debate, even by a small measure, the entire immigrant community pays attention. Today, that attention is no longer optional. The law has passed. And green card holders need to understand exactly what it says, what it requires, and what happens if they don't comply. The guidance issued by immigration authorities today was not routine. It was not symbolic. It was not a proposal. It was law. Analysts, after briefings, described the new provisions as expansive, operationally immediate, and perhaps most importantly, retroactively applicable in certain circumstances, meaning some green card holders may already be out of compliance without knowing it. But legal exposure only becomes a crisis if the affected person hesitates to act. Green card holders who respond quickly and correctly will be protected. In fact, the response window available right now is among the most important we've seen in recent immigration history. Here's what we know. Within days of the law's passage, USCIS began updating its compliance frameworks. These weren't minor administrative adjustments. These were structural enforcement changes, systems that federal immigration authorities only deploy when they are preparing to move from policy to enforcement action. The clock is already running. Tonight, legal sources confirmed that the new immigration law targets several categories of green card holders, including long-term permanent residents, who have recently delayed naturalization proceedings, individuals who, for years, were in a kind of comfortable legal limbo. That limbo is closing. The law hits continuous residence documentation requirements. It hits physical presence obligations. It hits the conditions under which a green card can be revoked, suspended, or flagged for review, conditions that were previously difficult for the government to enforce efficiently, but are now, under the new framework, far easier to track. In other words, Congress targeted the gray areas, the compliance gaps that had existed for decades, the procedural loopholes that immigration attorneys used to protect clients who had let requirements slide. This is what made the law's passage so urgent to watch. The new provisions aren't just symbolic, they are actionable. They represent the kind of legislative shift that can affect millions of people if they are not prepared. And the government, understanding exactly what these tools can do, has built enforcement mechanisms that move faster than the traditional immigration court backlog. The law doesn't require you to do everything at once, but it does require you to know what's changed. And right now, millions of green card holders do not. And here's where the story becomes even more consequential. Legal analysts now believe that this law was designed to test the compliance posture of the permanent resident population, to identify who is current, who is not, and what level of enforcement action is politically and logistically feasible. Congress wanted to see whether green card holders would treat this as another paper announcement, something to file away and ignore. But the legal community isn't letting that happen. Immigration attorneys speaking with major news organizations under anonymity describe the legislative shift as a pressure calibration, a way to move millions of people toward naturalization, toward stricter documentation, or toward the door, depending on their status. But green card holders who act now prove that they are both informed and compliant. Their preparation is not only strategically smart, it sends a signal so clearly to immigration authorities that it dramatically reduces the likelihood of targeted scrutiny. That element matters because it shows that proactive compliance is a shield. It shows that green card holders are not passive recipients of whatever enforcement wave comes next. They are active participants in their own legal protection. As reports continued coming in throughout the day, we learned more about the scale of what this law actually touches. Permanent residents in the employment-based categories face new documentation requirements for maintaining their status during job changes, a provision that targets one of the most common and previously untracked vulnerabilities in green card compliance. Residents who have held green cards for more than 5 years but have not filed naturalization applications are now subject to enhanced presence verification, something that had been discussed for years but never codified until today. Family-based green card holders with pending adjustment cases are being advised that the new rules may affect the timeline and processing priority of their applications. This wasn't just a technical tweak. This wasn't just a bureaucratic update. This was a structural realignment of how permanent residency is monitored, maintained, and enforced in the United States. And enforcement capacity is the one thing the federal government has steadily expanded since the previous immigration reform cycle. For every gap that existed in the old system, Congress has now provided a mechanism to close it. Remember, many green card holders thought the system would stay the same indefinitely. They thought permanent residency was, in practice, truly permanent, requiring little attention once the card was in hand. They thought the government lacked both the will and the infrastructure to enforce compliance at scale. But tonight, the exact opposite is happening. Enforcement frameworks are expanding, not contracting. The bipartisan appetite for stricter immigration compliance is stronger now than it has been in 2 decades. And the technology available to USCIS, DHS, and border enforcement agencies makes the old assumption of too many people to track effectively obsolete. The legal landscape has shifted, and those who understood that early are already several steps ahead. What makes this moment so significant and so urgent is that this law passed at a time when the immigration debate in Washington is under pressure from multiple competing directions. Conservatives want stricter enforcement and faster deportation of status violators. Business lobbies want a clear pathway that protects skilled workers and employment-based residents. Family advocacy groups want protections for long-term residents with deep community ties. And civil rights organizations want due process guarantees that prevent wrongful status revocations. Congress is balancing these demands while simultaneously managing a backlog of immigration cases that numbers in the millions. And when legislators in that position make sudden moves, they're not always doing it from a coherent long-term plan. Sometimes they're doing it from political pressure, sometimes they're doing it from the need to show action. And the people caught in between are the green card holders who didn't see it coming. The Department of Homeland Security's formal guidance, now distributed across all major immigration platforms, was designed to signal that the federal government is not willing to allow non-compliance to continue at its current scale. Officials said plainly that green card holders who fail to meet the new documentation and presence standards are acting inconsistent with the terms of lawful permanent residence. That is careful legal language for, we are preparing to act and you have been warned. You don't usually hear that kind of language from DHS unless enforcement operations are already being planned at the field level. Meanwhile, senior immigration officials addressed the public in a direct and measured statement today. They said, permanent residence is a privilege that carries responsibilities, and those responsibilities are now being more clearly defined. They said, we encourage all green card holders to review their documentation, consult with qualified legal counsel, and take the steps necessary to remain in full compliance with the law. And they said, those who act in good faith and promptly address any gaps in their status will be treated accordingly. These are not empty reassurances. These are statements from an agency that understands the scale of what it's asking and is leaving a window open for those who move quickly enough to use it. Here's what makes the situation even more pressing. This law wasn't passed in isolation. Along with the core green card compliance provisions, several related actions are moving simultaneously. The State Department has issued updated guidance on re-entry permit requirements for long-term travelers. USCIS has quietly revised the standards for demonstrating physical presence in continuous residence applications. And congressional committees are already signaling follow-on legislation targeting the naturalization timeline for long-term permanent residents. All of this happened within the same legislative cycle. When the government moves multiple immigration policy pieces at once, it means something larger is underway, a structural tightening that will define the rules of permanent residence for years, possibly decades to come. Legal analysts are now considering several possibilities for how this law reshapes the permanent residency landscape. One is that the government is preparing a large-scale compliance audit, a systematic review of green card holders who have not filed for naturalization within expected timelines. Another is that the administration is attempting to accelerate the naturalization pipeline by creating pressure that makes staying on a green card indefinitely less attractive than it used to be. A third possibility, the one worrying immigration attorneys the most, is that the government is attempting to create new grounds for status revocation that will survive legal challenge precisely because they are framed as compliance failures rather than punitive actions. But green card holders who act now take that card off the table. They don't wait for a notice to arrive. They don't wait for a deadline to pass. They don't wait for the system to find them first. They get compliant, get documented, and get protected before enforcement begins in earnest. What we're watching now is a test of preparation. The government wants to see how many permanent residents are paying attention and how many will be caught unaware. Green card holders want to show, and need to show, that they are serious, compliant, and informed residents of this country. Immigration advocacy groups want to prevent wrongful status loss among people who simply didn't know the rules had changed. And the courts want to prevent an enforcement surge that overwhelms due process protections before legal challenges can be mounted. Tonight, we've heard from immigration attorneys who are now fielding emergency consultation requests at rates not seen since the last major policy shift. They say the most urgent cases involve green card holders who have spent more than 6 months outside the country in the last 2 years without proper documentation. They say the second highest risk category involves those who have changed employers without properly updating their records with USCIS. And they say the government's decision to move forward without an extended public comment period is likely part of a broader strategy intended to catch the non-compliant before they can self-correct quietly. But informed green card holders are not sitting still. In fact, the most prepared are already moving. Their response, swift, documented, and legally sound, sends a message to immigration authorities that they are residents in good standing. And it sends a message to the courts that the community is not waiting passively for enforcement to define the terms of their lives. As the days ahead unfold, we expect more details to emerge about exactly how this law will be implemented at the field level. But what we do know is that Congress's action was deliberate. It closes loopholes that had existed for a generation. It creates new obligations for millions of people who were never told they had fallen behind. And it gives authorities tools they have never had before in such concentrated form. What happens next will depend on what green card holders do in the days and weeks immediately ahead. If they act now, review their documentation, consult an attorney, begin naturalization proceedings if eligible. This moment will be remembered as the warning that saved their status. If they wait, federal authorities have already shown they are not. They have shown they are ready to enforce. They have shown they have the tools to do it. And they have shown they intend to use them. And tonight, for the first time in years, the green card system appears to be entering a new phase. The processing centers are preparing, the enforcement systems are updating, and Washington is quiet in the way that only precedes something significant, too quiet. And when Washington goes quiet on immigration, it means the next move has already been decided. Because tonight, every green card holder in America learned something that many learned too late in previous cycles. The rules can change overnight. Silence from the government is not safety. It is the space before enforcement. And preparation today is the only real protection tomorrow can offer. This story is far from over, but tonight, one thing is clear. The era of passive, unmonitored permanent residency is ending. The window to act, to get compliant, get documented, and get protected is open right now, but it will not stay open forever. And for every green card holder watching this tonight, the most important thing you can do is not turn this off and assume it doesn't apply to you, because tonight it does. And we will be here watching every detail as the next phase of American immigration law unfolds.